Good morning, good evening, good night. And I'm having issues loading Rumble. I don't know why. And I had perfect internet all day, and now I see right up there on my screen low bar. This is going great. John Gordon, Rumble won't load for me. No, me neither. So no Rumble today. Sorry. Don't know why. Don't know how. Don't know when. There's something wrong with light. Hold on. There. There I am. Okay, let's router to mobile internet. Okay. What do you mean still can't see me? Can you see me now? Oh, there I am. Here I am. Hey, oh. Oh, what a day. I had a day off from work, so I got a lot of work done. Hi, EU. You can see me. Yeah, my internet perfect all day, and just half an hour ago. Okay, I need to set up the rumbles and stuff like that. No access. Okay, what else can I do? And I have to sneeze. Jesus. Hi, Sonny. Good to see you. John Gordon, Fun Size, Jeff H, Atheist Ant, Pixie, Tia, Mads. Hey, Gigi. No, I can't get Rumble to work at all, so they might have some issues I can't do anything about. Hello, fellow Vikings. Yes, you are my Viking family. Yay. All right. What's up today? Today has been a pre-scheduled hearing. It's about a motion to dismiss. And also, it should also contain some about the witness list, that the defense needs the complete witness list, that of all 737 people from the state today. Hello, everybody. Unbronzed are here. Hey. Tianina. Yeah, Mexican Viking. Oh. That's an interesting combo. Hello, neighbor. Hi, neighbor. And yeah, Gigi is doing good. And for you who are my regulars, you know Gigi has been very under the weather. And thank you for all your thoughts, all your prayers, all your wishes towards her over the last few weeks. And well, she is recovering, and she's here. She's here. Yay. At the same time, I invited Baker over here, but they have a football game or a soccer game for you Americans. So maybe when they are done, I don't know. I also invited Dave over. How do I spell hello in Swedish? Either hallå or hey. Sonny Tanner, can I ask early? Yeah, sure. Go right ahead. If I can answer it, I will. If I can't, I will ask Dave when he gets here. So I will star your comment. Coffee. So we have Mexico, Australia, and United States and Denmark represented in the chat so far. Anyone else? GG got bumped off by an ad. Oh, for you have to be kidding me. Yeah, for you who don't know, when I turn on video monetization, which allows you to buy memberships and super chats and stuff like that, I can't take away the option for ads. And there's absolutely nothing I can do about it. Okay. Oh, sorry. What is Charlie's defense doing now? Appeal, mitigation, plea? Charlie Adelson, they are in the... His sentencing is in a few days. But they don't have an option for that, I think. Well, not to my knowledge. The plea, well, the state can always offer him a plea if he testifies against Donna and Wendy, I suppose. But other than that, they are preparing for their appeal. That would be my guess for it. And other than that, wishing that his mother never called him. Telling, yeah, if you don't know about the Adelson, Donna Adelson is in custody. She's been that for a week now. And this morning, no, not for a week, for a few days. This morning, she was released from Miami, whatever custody she was in Miami, for transfer to Tallahassee. And I would suspect that she is brought there, and we will soon get a first hearing from Tallahassee in a few days or in a day or two. And when it shows up, I'll be there. Oh, starting. I just started 8 minutes ago. Basis for appeal. Well, it's like every other first appeals. It's about if the judge made a mistake. If a denied motion should have been approved, or if an approved motion should have been denied, or if some of his decision in the trial was very, very wrong. So that's the first set of appeals. Hi, Dave. Hey. Sorry. But we are here for Young Thug. Unmute. Sorry. And yeah, today's motion for dismissal. And well, we'll see how that will go, because there are motion for dismissal of more or less the entirety of the RICO trial. Now, this, in my opinion, is of a Hail Mary. This close to a trial, and yeah, but you never know, and it will be interesting to see the arguments and how the judge. And yes, this started this morning, so I could have done this live, but we all know this judge is always late, and his 15 minutes or recess can be an hour and a half. So That's why I chose to wait, so we can do it all in good time. All right. Let's see what will be going on.
Good morning, council's interested parties. We're here on the record in the matter of the state of Georgia versus Khalif Adams et al. in 22 SC 183572. Go ahead and take roll for the morning. Mr. Stillwell, Mr. Sharp, good morning.
Good morning.
All right.
Okay.
Mr. Williams, Mr. Steele, and Mr. Adams and Ms. Renard. Good morning, council. All right. Mr. Kendrick and let's see, Mr. Weinstein, Mr. Huey, and Mr. Matthews Jr. Good morning, sir. Good morning. Mr. Nichols and Mr. Harvey, Mr. Garner, and Ms. West.
Yeah, and for you who don't know, that in the last year, when the state said we are ready for trial, there were 28 defendants. Now it is that they are down to 6. How Sal wonders, how long am I going to go? I don't know. Hopefully no more than 2 hours. Hopefully.
Good morning. All. And Mr. Ryan and Misty Williams. Good morning. All right. Mr. Floyd and Mr. Uhelski, good morning.
They pled out or were dismissed. What happened to the rest of the defendants? Pled out, dismissed. A few of them have agreed to testify in this trial, but not that many. Hello, Flux.
Okay. Council is consistent with our business for today. I have several things I need to take up with you all.
Dave, your speak to text is.
And since Mr. Floyd, you were here, I assume that you were going to argue on behalf of the state the response to the plea and bar motion to dismiss General Demur. Is that correct?
Yes.
Okay. All right. I had some other stuff. Is Miss Love and Miss Hilton going to be back later on?
No, they will. We're kind of divided at this time, as they know, across the way there. And one be Ms. Love and Ms. Hilton are before senior judge comes at this time. They're going to be back over here as soon as that's.
Okay. All right. Okay. Fine.
And for the record, Your Honor, they'll be needed for every other matter. I think of course besides this plea bar.
Okay. All right. Okay, Mr. Steele, are you prepared to at this point in time to take up your matter?
Always.
All right.
Good day.
You only got 15 minutes, I'm telling you.
an issue, but if you stop me, then I will,
Well,
tell me when, I'll make it a record,
Okay.
and in your absence or whatever, but obviously I gotta do this perfect. And Your Honor, happy holidays to the court reporter, who has been unbelievable, prosecution team, Mr. Floyd, good to see you, and everybody here. And thank you, Mr. Adams, let me work with you on this case. And Mr. Williams. Your Honor, we did file what you just said, the plea and bar motion to dismiss general demurrer.
that was filed on the 11th of, I should say 2nd of November of this month, and the state's response was filed on the 9th of this month, which I have both read and considered.
And Your Honor, I have some cases to make it a little easier, hopefully, for everybody.
That's a
As we
lot
go along.
of files.
Approach, Your Honor.
You may, sir.
So, Your Honor, in support of our plea and bar, this challenges every count of the indictment that Mr. Williams is in. Count 1, the RICO count that affects every person wrongly charged here. And then count 56, 57, 58, 59, 60, 61, and 62 regarding Mr. Williams. And I'm first going to give the Honorable Court an answer to your questions. But the first case I've given to the parties in this Honorable Court is Heath, H-E-A-T-H versus State. It's 394 Georgia Appeal 84, 825 Southeast 2D 474. It's 2019. I had the honor of representing Ms. Heath on appeal. I was not the trial lawyer. The Court of Appeals wrote, and it's on the first page, right-hand side, beginning of the opinion, Your Honor. After jury trial, Christine, which is K-R-I-S-T-I-N-E, Heath, was convicted of homicide by vehicle, first degree, homicide by vehicle, second degree, 5 counts of serious injury by vehicle, failure to
I read it.
stop.
I read it. And that was the case involving a serious injury by vehicle, and the major issue turned on because defense counsel did not file this particular motion. They're ineffective. Correct?
Yeah, and in it specifically on page 3.
So I'm having an issue with the timing.
Exactly. And jeopardy attached. That's why I didn't file it previously. That's what I've been taught by the courts. So once we had the jury, that's why I filed it, I think, the next day after jury selection. And what the court tells us is on page 3, right-hand side, first full paragraph, Heath argues that trial counsel was ineffective for failing to file a general demurrer because the indictment omitted material elements of the counts charging homicide by vehicle and serious.
Dave, I'm not going to say anything about cultural appropriation because later this week I'm going to do dramatic readings of Young Thug lyrics.
Injury by vehicle, which is what we're doing. There are elements that are material in this indictment on the counts I just said that are not pled. On page 4, Your Honor, of 10, on the left-hand side, 6th line, in that regard, to withstand a general demurrer, an indictment must recite the language of the statute that sets out all, I stress all, the elements of the offense or allege the facts necessary to establish violation of a criminal statute. If either of these requisites is met, then the accused cannot admit the allegations of the indictment and yet be not guilty of the crime charged. However, an indictment which omits an essential element of the predicate offense in a count charging a compound offense, such as vehicular homicide or serious injury by vehicle, can nonetheless satisfy the requirement of due process as long as the indictment charges the predicate offense completely in a separate count. An indictment alleging merely that the accused acts were in violation of a specified code section is defective. We won that appeal. The Honorable Court of Appeals of Georgia granted the relief I sought. The state of Georgia then sought and received cert from the Supreme Court of Georgia, and that's the next case, State versus Heath. That's why I flipped the title. And that's 308 Georgia 836, 2020 case. And on page 3 of 4 of the copies I've given this honorable court and the parties, the state was arguing that there was no surprise, that Ms. Heath knew exactly what she's charged with, as did her lawyer. And then at the very bottom of 3 of 6, Your Honor, 4 lines up on the right-hand side, for purposes of the general demure, however, it matters not that the defendant has notice of the charges. That is because a general demure challenges the substance of the indictment and asserts that the indictment is fatally defective and incapable of supporting a conviction. If a defendant can admit each and every fact alleged in the indictment and still be innocent of any crime, the charge is subject to general demure. And a general demure, as you just said, Your Honor, it's on the right-hand side, page 4 of 6, first full paragraph, 8th line down on the right-hand side. We first note that because a general demure challenges the validity of the indictment, a general demure may be raised after jeopardy has attached at any time during trial. So, as the court already noted, it is timely, and if you deny it, but the appellate court agrees, or the Honorable Supreme Court agrees, Mr. Williams and the others are placed in jeopardy, they cannot be retried. This ends the case. The next case, Your Honor, is Tate, T-A-T-E, hyphen Jesurum, J-E-S-U-R-U-M versus State. Your Honor, that's 368 Georgia Appeal 710, 2023 case. And in this case, the Court of Appeals of Georgia wrestled with whether demure was good, because the Supreme Court of Georgia on a drug offense, which affects Mr. Williams in his substantive accounts, and it affects other people, possession of drugs with intent to distribute. I know it affects Mr. Stillwell. I know it affects Mr. Nichols and others. The wrestle was the indictment, the grand jury did not allege knowingly. The Supreme Court of Georgia has said that a person, if I just possess cocaine and I'm charged with intent to distribute, it's not the intent to distribute, it's the knowing possession of cocaine. Because if I have something that I don't know is cocaine, then I am not guilty of that crime. It's not.
Okay, so this is the baseline for this motion, as I understand it, that the state has alleged in the RICO that all possessions of drugs, no matter who it was in the gang, is with the intent to distribute. And according to Mr. Williams' defense lawyer here, that's wrong. You have to be very specific in that language, according to him. And he seemed to have some case law to back it up with. Let's continue.
A strict liability crime. I have to know that I'm possessing cocaine. That became an element of the offense by the Supreme Court of Georgia. It's not in the statute. The majority opinion, 2 judges, the Honorable Judge Rickman, writing for the majority, 2 judges in Court of Appeals, said no, that indictment is good. Yes, the indictment did not charge knowingly. Yes, knowingly is a material element of the charge. Yes, the trial court must, and you're going to have to, if it goes that far, Your Honor, charge on the knowing or the mens rea requirement. But if the indictment says the word unlawful, unlawful has this great umbrella, and that means knowing, that means it was charged. The dissent is well written, well thought out. It's the Honorable Judge Dillard, D-I-L-L-A-R-D, and Judge Dillard wrote the dissent, Your Honor, and he's obviously one judge, so it's the dissent, and that starts on page 4 of 9, and he said, that's wrong. He said that, and it's on 4 of 9 on the right-hand side, 7 lines down to the right. But importantly, an indictment is to be strictly construed against the state when a general demure has been filed against it. On page 5, Your Honor, Judge Dillard goes through the history of an indictment. And on page 5 on the right-hand side, first full paragraph, Judge Dillard wrote, but the jurisprudential landscape has changed dramatically since.
Yeah, for later this week, I will do dramatic reading of Young Thug lyrics. So if you have suggestions, because I don't think I've ever heard anything he has ever done. So, yeah, but I will write that one up.
Die, which is DYE, that's the case. And most of its progeny were decided. Indeed, as the Supreme Court of Georgia has explained, the omission of mens rea from an indictment renders a charging instrument void because it is an essential element of the crime. And in doing so, our Supreme Court noted that if an indictment fails to allege all the essential elements of the crime, for crimes charged, including the required mens rea, it violates due process, is void, and cannot withstand a general demurrer.
That's a dissent, right?
Exactly, 2-1. And on the right-hand side, Your Honor, Judge Dillard notes on page 6 of 9, 1, 2, 3, 4. 7 lines from the top. Finally, our Supreme Court has also explained that the adjective, quote, unlawful, end quote, means not authorized by law, illegal. It does not mean this, this all-encompassing mens rea of knowingly. And that's what Judge Dillard wrote in the next paragraph, fifth line. Unlawfully does not sufficiently act as a substitute for the essential element of knowledge or knowingly in charging documents. And this is a drug case, Your Honor, so it's going to be relevant here. I'll get to the indictment in just a moment. So the issue here is whether the indictment is proper as to count 1, which is the RICO conspiracy count, as well as the other counts charging Mr. Williams. And I know everybody here adopts this motion for their own use. The next case, Your Honor, is XIULU, Ruan, RUAN versus United States. Your Honor, this is 142 Supreme Court, 2370. It's 213 Lawyers Edition 2D 706, 2002 case. And here on the case that I've given, or the copy of the case I've given, the signed recording of parties on page 8. It's in Division 2A, as in Elisa and Alpha, on the majority opinion.
Okay, this is very technical, but so far he has tried to reinforce his argument about, in order to bring this kind of charges forward, you have to be really specific in the language in which you bring the charges, with intent, with the mens rea, and stuff like that. And that is his argument so far. And he has a few case law, and now he's talking about a majority decision or something. But let's keep going. How did the state get around these defendants' quick and speedy trial right? They started jury selection in January of this year. And as with many other states in the United States, the trial technically starts when the jury selection starts. And they finished the jury selection about a week ago, because it's a 6 to 9 month trial. So they needed juries who could sit on a jury for at least half a year. And that's how they got around the speedy trial. For me, it's a bullshit argument. Oops, only half an hour in, but hey. Man says the mens rea here could just be knowingly part of a gang. No, it's a RICO charge. No, if I remember correctly, they had this in a previous hearing a couple of months ago about yeah, I don't remember the exact words now. But since they are bringing forward this motion now, either the prosecution or the judge will address the mens rea regarding the overall charge of RICO or the separate charges. So hopefully they will explain it to us.
And here, the Honorable Supreme Court of the United States, which we follow, wrote, first, as a general matter, our criminal law seeks to punish vicious will. Next paragraph on the right-hand side on page 8, last paragraph. Consequently, when we interpret criminal statutes, we normally start from the long-standing presumption traceable to common law that Congress intends to require a defendant to possess a culpable mental state. We have referred to this culpable mental state as scienter, S-C-I-E-N-T-E-R, which means the degree of knowledge necessary to make a person criminally responsible for his or her acts.
Yeah, for you who have seen more of this, you know that this trial had 28 defendants in the beginning, and they couldn't find public defenders for all of them. The public defender's office, well, they couldn't represent all of them, just maybe a handful, and so they had to outsource it to private offices, law firms and stuff like that, who was prepared to do it. And then they offered at first a fixed rate of $7,500 for the entirety of the proceedings. Few takers on that one. And then they offered twice that, so $15,000. Now, $15,000, that's a decent chunk of change. I mean, that's more or less for many people, that's 6 months' pay. But these are lawyers. These proceedings has already been going on since September of last year? August of last year. So we are already almost 18 months into this. So, yeah, for me, that's ridiculous, because if the state wants to bring a RICO case, they should cover the actual cost of the defense, in my opinion. Armstrong's private defense attorney took on her retired defense for 10 grand. Yeah, because if you can have one client, because then you can always get in more cash from other clients. Once this trial starts, that's all they can do. Because this case has precedent over more or less everything else they do. If they call for a hearing, all lawyers have to be there for all the defendants. Let's see here. Atheist and I'm no lawyer, but the whole idea of RICO cases seem to deny you due process by default. Yeah, in my opinion, which might be right, which might be wrong, I don't care, is that, for instance, in this case, with the YSL-gang and Young Thug and everything, they allege crimes back to 2012. 11 years ago, and from 2012 up to 2021. These are crimes they couldn't prove separately. Most of these, they couldn't even bring charges towards. So in my opinion, this RICO trial is the state's wishes to, by sheer volume of allegations, get a conviction through the gang affiliation RICO stuff. That's my opinion. Yeah, their life is this case for a year. Yeah, but they already been doing this for over a year. These most of these lawyers who are currently here, and once the trial starts, 6 months is conservative. I mean, they have added in the last 2 months over 300 new witnesses, the state. I don't see this going. I mean, I'll be very happy if it takes only a year. Only. Yeah, but when I started talking about this case, what was it, back in May or June, I said, I would cover this because it interests me. I mean, back then I thought, well, 6 months, yeah, it's a long time, but I can cover it by mixing live streams with recaps and maybe once every second day, because sometimes once technical stuff goes in, it's extremely boring. So I would rather take 6 expert witnesses for 2 days and mush them together in a maybe 2-hour stream once every 2 days. But that's the way it is. I will be covering this case gavel to gavel in some way, shape or form. Live streams, recaps, and stuff like that. Or the occasional video if I'm extremely busy at work. And you know that. I still practice law. I have to do work. That pays the bill. All right, let's continue.
In the presumption of scienter, we have read, and this is what I'm stressing, we have read into criminal statutes that are silent on the required mental state, meaning statutes that contain no mens rea provision whatsoever, that mens rea, which is necessary to separate wrongful conduct from otherwise innocent conduct. Unsurprisingly, given the meaning of scienter, the mens rea we have read into statutes is often that of knowledge or intent. When a statute is not silent as to mens rea, but instead includes a general scienter provision, the presumption applies with equal or greater force to the scope of that provision. We have accordingly held that the words such as knowingly modifies not only words directly following it, but also those other statutory terms that separate wrong from innocent acts. On page 12 of 25, Your Honor, in Division 3, at the very bottom of the left-hand side, in the center, the court wrote compare or United States versus RESENDIZ versus hyphen Ponce, PONCE 549 US 102. And then the 2007 case, criminal indictment must set forth all elements of the charged crimes. In this case, Your Honor, as Tate Gerson, in my irrelevant opinion, suffers because the Court of Appeals majority opinion, the 2 judges, did not read into the statute what the Supreme Court told us, that you have to have a knowing element for a drug offense. The next case is Elonis, ELONIS versus United States. It's 575 US 723, 2015 case. Your Honor, on page 9 of 35 of the copy I've given this honorable court and the parties. In Division B on the right-hand side is in Barry and Bravo. The High Court wrote that the fact that the statute does not specify any required mental state, however, does not mean that none exists. We have repeatedly held mere omission from a criminal enactment of any mention of criminal intent should not be read as dispensing with it. This rule of construction reflects the basic principle that wrongdoing must be conscious to be criminal. On page 10, Your Honor, left-hand side, 8 lines up from the bottom paragraph, the court wrote, we therefore generally interpret criminal statutes to include broadly applicable scienter requirements, even where the statute by its terms does not contain them. And this is all called, Your Honor, the mens rea doctrine. So, out getting to our case, Mr. Williams' case, and everyone is involved in this. If you look at the indictment, which is 22 SC 183572, State of Georgia versus Mr. Adams et al. Your Honor, the first count is a conspiracy to violate the Racketeer Influence and Corrupt Organization Act. And when you look at that indictment as a whole, which I have done multiple times, the state
You gave me the wrong indictment.
You have the indictment? You said you have the indictment, right?
No, I said, you might want to take a look at this one.
It's coming next.
Oh,
So I did not give you this indictment. I thought you had it, but I can hand you, with the state's permission, my copy.
no. Are you talking about the indictment in this case
Yeah.
or the Trump indictment?
Our case.
All right, this will be interesting because Georgia, as you know, is the state where the same prosecution team are indicting former President Trump under the RICO Act. So apparently, Mr. Young Thug's lawyer will do comparisons in the charges. This will be interesting.
Okay. And this is what you handed me.
I know, I thought everyone had our indictment.
No, you handed me the Trump indictment.
That's coming next.
Okay, all right. I have our indictment. Okay.
Yes. So on page 12, Your Honor, if you look at our indictment, page 12.
All right.
Now, I don't know. I haven't checked.
The grand jury alleged, on the top of that page, with the offense of conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, 16-14-4C is in Colette and in Charlie, for said accused, together with unindicted co-conspirators in the state of Georgia, County of Fulton, on or between 24th day of January 2013, the 8th day of May 2022, and this is where I stretched, did unlawfully, there's that word again, conspire to acquire and maintain directly or indirectly an interest in and control of the United States currency, other personal property, through a pattern of racketeering activity in violation of 16-14-4, A as in Elisa, and Alpha, and while associated with an enterprise, did unlawfully again conspire to conduct and participate directly and indirectly. So that's from the statute. But what the Supreme Court of Georgia has told us, what the Court of Appeals of Georgia has told us, is the following.
Yeah, it will be. I need to go into the.
May I approach, Your Honor?
As soon as I start talking, they start talking. Now I have to go into the and see if there actually is that much. Oh, Christine has a question.
Mr. Steele, it certainly would have been nice for you to send me these cases
I will live stream when it starts Monday.
earlier so I could have read them.
Okay, and I would always want to. So the first case is MacArthur, MC, capital ARTHUR versus Beach, which is spelled BEECH, Haven, HAVEN, Baptist Church of Athens. Your Honor, if you look at page 8 of not
a good number of
11
case law on this.
this case that I've handed out to this honorable court and the parties. On the right-hand side,
He has a good number of case law on this issue. Now we still have to listen to the state replying to this. But that's a decent number of case law.
fifth line up, center.
What page?
8 of 11. The right-hand side, fifth line up from the bottom in the center. The Honorable Court of Appeals wrote, the RICO statute also prohibits a conspiracy to violate the statute. And they cite to footnote 41, which is what we're charged with, OCGA section 16-14-4C as in Collette and Charlotte. Under Georgia law, a person may be found liable for RICO conspiracy, and this is what I stress, if they knowingly and willfully join a conspiracy which itself contains a common plan or purpose to commit 2 or more predicate acts. The next case, Your Honor, is Cotman, C-O-T-M-A-N versus State, which is 342 Georgia Appeal, 569, 2017 case. Your Honor, on page 17 of 22 of the copy of given this honorable court.
This is not me. This is Law and C-word, and it's technicians looking at a cable going, I wonder what this is doing, whoopsie, and then try to put it together again. How long did this last? Jeez. Okay, there they're back.
Cases that I know about. So, this is not.
We just got 10 minutes of
okay.
argument.
Mr. Steele, I understand. I'll wait and hear what Mr. Floyd has to say about that. But
No, unless you tell me not to, I'd like to answer your question. But if you look at the word unlawful, unlawful means illegal.
But that's what the statute tracks.
But
So how can I be asked to include something else that the statute doesn't necessarily require? I mean, I know that the state always, has to prove for a conspiracy or for other criminal charges, we offer the jury intent, right?
you have to.
I mean,
Yeah, exactly. What does this button do? I mean, and this is why I chose to start later, because this happens all the time with Law and C-word and with this particular judge, that his 15 minutes recess, an hour. And all of a sudden, Law and C-words technicians goes full, I can't say that word. But you know what I mean. I might say it after 2 hours. But they are back, so let's continue.
the state's required to prove that, right?
And it's not an indictment. I mean, if you just think that through, The old law,
But does it have to be in the indictment?
yes, those are the Supreme Court cases I gave you. And that is exactly the dissent in Tate Jerusalem that's on cert. And if you think it through, I'm going to request charges on knowing and willful conspiracy. You have to join it knowing and willful. I believe this honorable court will grant that and will charge on that. You are now charging on essential elements that are not alleged in the indictment. If you just think that through, there is a disconnect. And yes, Georgia courts held that for a long time, but as Judge Dillard writes, he writes a good dissent. He goes through the history. He said that law changed years ago. And that's what I wrote to, or read to your honorable court on page of the dissent. Page 509 on the right-hand side. Judge Dillard wrote, it's the first full paragraph, but the jurisprudential landscape has changed dramatically since Dye, and most of its progeny were decided. Indeed, as the Supreme Court of Georgia has explained, the omission of mens rea from an indictment renders the charging document.
How can he base his argument on a dissent opinion? Sometimes, and I remember Dave talking about that, or if it was Jeff who talked about that later on there's an old case, which I don't remember right now. I only remember the discussion about it, that the dissent opinion became the law. And the actual how to interpret it later on. Not at that immediate, but just that when the Supreme Court has a written dissent opinion, they can still take that into account. And if I have to ask Dave if he shows up. I will star this question because I do remember the discussion about it. Ashton, dissents often get the law right when lower courts screw it up in the decision. Okay. Thank you. That's a good answer. Thank you, Ashton.
Void. Unlawful is not a mens rea. Unlawful means illegal. Well, I could illegally be holding cocaine. Doesn't mean I know I'm holding cocaine. You're going to have to charge on knowledge. Otherwise, your charge is defective because you're not giving an element of offense. And the element of offense, the grand jury buying through the Fulton County District Attorney's Office with all their resources, they blew this indictment. They failed to do it. And that's why I gave you Donald Trump. It's not like this is unknown. They failed to do it. So, I accept whatever this honorable court's ruling is. And if it's adverse, I believe I have a dual track. I will obviously go on trial, but I just respectfully request if you can get your order in, I will file a notice of appeal. It's a direct appeal. It will not stop our trial, it's my understanding. And I will ask the appellate court to take this up during our trial. And if they grant it, then we could abort the trial at that time.
Okay, that's interesting. So if the judge chooses to deny the motion, then the trial will go forward and the defense attorney will move forward with his defense. But he will appeal it to the higher court if it is denial of motion. But if a higher court decides that, yes, we grant this appeal and the judge was wrong, then that would abort. YouTube, this is legal speak, nothing else. This will take the trial out of the docket if a higher court decides to, no, Judge, you made a wrong decision. That's interesting. This will be an interesting trial. Even though it's at least 6 months of trial, there are some things in it that will be really interesting. And for you who have seen my coverage of this since the beginning, we checked some during the Daubert. No, not the Daubert. Was it the Daubert? I don't care. When they when they checked the experts pre-trial, there was a lot of the experts who I wouldn't trust with a hammer and nail. Suspend is the word I'm looking for. Thank you. Thank you, Mads. Suspend, not the A word. Thank you. My chat is so helpful. Yeah. So some of the experts I will definitely have a check on, because you all remember Pinch and Zoom guy, the state wanted in as a I will play here and I will be back in a bit.
Count 56 and 57 are the same exact issues. Now we're dealing with Mr. Williams charged wrongly participation in criminal street gang activity. And it says again, and I'm reading 56, Your Honor, OCGA 16-15-4D, as in David Delton, for the said accused, County of Fulton, State of Georgia, between 12th day of May 2018, 8th day of May 2022, while occupying a position of organizer, supervisor, or other position of management or leadership of the criminal street gang YSL, did engage in, directly or indirectly, or conspire to engage in any one of the following acts of criminal street gang activity of YSL, to wit, murder, aggravated assault with deadly weapon, armed robbery, hijacking a motor vehicle, sale of marijuana, possession of marijuana with intent to distribute, theft by receiving a firearm, and possession of a weapon by a convicted felon. And then on 57, same crime, that targets the 9th day of May.
Okay, what happened? Well, neighboring cat decided to pay a visit, and Jingles didn't like it, so it was a lot of screaming outside, and I'm expecting a call from neighbor because Jingles won. Yay. The joys of having a farm cat.
2022 did unlawfully, again, that's all it says is unlawfully, while associated with criminal street gang YSL, participating in criminal street gang activity through the commission of at least one of the offenses enumerated in 1 of 16-15-3, possession of marijuana intent to distribute, possession of codeine with intent to distribute, possession of cocaine, possession of firearm during commission of felony, as alleged in count 58, 59, 60, and 61 of the indictment. If you look, Your Honor, at Rooks, ROKS versus State, case I gave you,
I've read Rooks.
not you.
I've read Rooks.
Okay.
But what do you want to point my attention to?
Say one more time.
What do you want to point my attention to?
Okay, and it's, if you don't mind, just cite for the record. It's S23A0783 is the site, October 24th, 2023. And on page 10 of 21 of the copy of the ensemble court, and the parties on the right-hand side, the first full paragraph, bottom, the Supreme Court of Georgia wrote, the evidence also was constitutionally sufficient for a jury to find Rooks and Clark guilty of the criminal street gang crimes which they were convicted. And then this one I'm stressing. To establish that Rooks and Clark participated in criminal street gang activity under 16-15-4, little a's and Elisa alpha, the state was required to prove 4 elements. 1, the existence of a criminal street gang defined in 16-15-3 as an organization, association, or group of 3 or more persons associated in fact with a formal and informal which engages in criminal gang activity. 2, the defendant's association with the gang. 3, that the defendant committed any of several enumerated offenses, including those involving violence, possession of a weapon, or use of a weapon. And 4, and this is what I'm stressing, that the crime was intended to further the interests of the gang. Those are material elements. There is nothing in count 56 or 57 for any of these other people who are charged with criminal street gang activity that says that the crime was intended to further the interests of the gang. 56 and 57, Mr. Williams can admit that he committed those acts. He can admit that. And just like count 1, the indictment is fatally defective because it does not set forth the elements. Mr. Williams demur as opposed to this.
Is it any other place in the indictment, in the preamble or anything such as that?
No, because this is not the count one. This is its own count of criminal street gang activity. So the answer to your question is no.
You said 56 and 57?
Yeah, if you look at the indictment, you're on page 90.
I have it.
I mean, he's doing good argument. Does it work? We don't know, because the state has its reply. They might have other case law, more local, Georgia Supreme Court or something else. Because the Georgia RICO trial has been around for a good while,
Okay.
even though it's...
So in those two counts, I'll just take them together. They failed to allege the essential element that we're going to ask the court to charge on. So you are charging on essential elements that are not contained in the indictment. The state is going to rely on the word unlawful. That is all they're going to do. They're going to say, well, the statute says unlawful, and they're going to ignore. They will have zero case law that says you can ignore what the United States Supreme Court has taught us, and the Georgia Supreme Court has taught us that when the statute is silent as to the intent, as to the mens rea, courts step in and mandate that that's an essential element. And that's the Alanis, E-L-O-N-I-S versus the United States case I cited earlier, as well as X-I-U-L-U Ron versus United States, which I cited earlier. And it's called the mens rea doctrine. Otherwise, all your court would charge is it's unlawful to do this criminal street gang activity. Mr. Williams doesn't have to do anything to promote the interests of the gang, which we know is wrong. That's what Rodriguez was about. That's what the court needs to charge the jury. So you're charging the jury on something not pled by the grand jury, and you're going to go back to, not you, but it puts us back in time to a fatally defective indictment. And the state, of course, is going to pound the table and say that's preposterous. We're tracking the statute. Just like the majority in Tate Jerusalem, they drew a much well thought out dissent in Tate Jerusalem, and it's on appeal, and they're ignoring that. They'll agree that you have to charge on these essential elements. So how is it not in the indictment? The next counts against Mr. Williams, Your Honor, is count 58, 59, 60, 61. They also include Mr. Kendrick in all of those counts, so it applies to him, and 62. And in all of those...
I don't think you're wrong, because this late in the proceedings, I mean, they've been at it for over a year. This late, if it would, in my opinion, if they had brought this at the beginning, as they started the jury selection, but then again, the jury selection is done. Now, double jeopardy applies. And so if he grants it, they're done. There's no way to recharge any of them. And so I do think the judge has that into account in his decision making.
Counts, Your Honor, the first four, 58, 59, 16, 61, are violation of the Georgia Controlled Substance Act. And then the different, it's possession of marijuana with intent to distribute is 58. Possession of codeine with intent to distribute is 59. 60, Your Honor, is possession of cocaine. 61 is possession of a firearm during the commission of those crimes: possession of marijuana with intent to distribute, possession of codeine with intent to distribute, and possession of
Yeah.
cocaine.
Yeah, I would agree. I mean, this possibly is just for opening up appellate issues. Yeah, I think the jury was sworn in Monday or Tuesday last week. So, yeah. If the jury has been sworn, the judge is less likely to dismiss or, no, in this case, grant here this motion. I would suspect he would rather pass it on to an appeal. Let me show you. Hold on a bit. This is my video monetization. As soon as I press on, these are my choices. Either let YouTube insert it themselves, or I choose. And I choose every 30 minutes. That way it was... so I don't know why everybody gets ads outside of that. But in my opinion, it's YouTube. They don't give a flaming fork about what I want. Because I don't want any ads in this stream at all. But they only care about the big channels who doesn't do trial streams. Those who stream only to get money. I don't stream for ad money. I stream because I'm interested in a trial. I stream because I know you're interested in how I cover the trial. Nobody here is interested in some twat going at it. Oh, look at this product and buy the... If you want to support me, you do, and YouTube, you do it via super chats or memberships, and YouTube will get paid anyway. Why the fucking ads? Oh, sorry. Oh, maybe it's every 30 minutes based off each viewer's time watching the stream. Oh, might be. Might be. Jackpot Springs never had an ad on you. Oh, you lucky bastard. Well, if you have a premium, you don't get ads. I said that about a week ago. I kind of want to do it like in 1 hour just grief of old videos because times are tough and stuff like that. And just a 1 hour video with random stuff I made and ads every 3 to 5 minutes. And then I have that video, which you can watch. And then I get some pay out of that one. But I mean, I can't... These fucking ads, I hate it. Thank you, Gigi. Thank you so much. Thank you, Gigi, for your $1.49. It's a diamond super sticker. Thank you so much. And TI is premium. Yay. Yeah, so I just wanted to show you because I know ads bother us all. And I just wanted to show you I don't have a choice. YouTube is making those choices for me. And I think they are absolute jackasses, because you have always had the choice of putting ads in your streams. Some of us, and the big tech channels who stream, they do it. I don't want it. But we are not here for me whining about ads. We are here for this. So let's continue.
Possession of cocaine. In all of those counts, Your Honor, the state fails to charge knowingly. That is a element of this offense. So when Mr. Williams puts up a defense that he did not know that there was codeine, did not know there was cocaine, did not know that there was this gun, the juries are going to have to decide that, and you're going to have to charge it. The state proved beyond a reasonable doubt, if you charge it, I will ask for it, that Mr. Williams had this knowledge. The Supreme Court of Georgia has written in the mens rea into the statute, because the statute only says unlawfully, and the Supreme Court of Georgia said no. There has to be knowledge, and that's on page 3 of 9 of the majority opinion of Tate-Drewsome versus State.
Hey, Kaiser.
In the first full paragraph on the left-hand side, the two judges said, nevertheless, Tate-Drewsome argues, and the dissent agrees, that in Duval, D-U-V-A-L-L versus State 289 Georgia 540-2011, the Supreme Court abrogated, within the context of an indictment alleging possession of a controlled substance in violation of 161330A, both the legislative directive of 17-7-54A and the well-established pleading rules upon which the courts and prosecutors of this state alike have relied for decades, but Duval cannot be so construed. To be sure, the Duval court held that possession of controlled substance is not a strict liability offense, and therefore the state must prove that an accused both knowingly possessed the drug and also knew that the drug he or she possessed was a controlled substance. That is my issue. I understand that the two judges in Tate-Drewsome said, but we're ignoring that. That's just for a charge. But I disagree vehemently on reading. You know, I love it. As the court, I love this. I mean, this is, you know, it's interesting. It's fabulous. And this indictment is fatal. It should have charged the mens rea. And you're going to be asked to charge. And I believe that you will charge. I mean, you'll follow the rules. But the issue, Your Honor, we just take off all these cases, just throw everything away. You are charging on elements of the offense. You will tell.
Yes, this channel is reaction, commentary, snark, screaming at judges, screaming at defense, screaming at prosecution. I don't give legal, medical, or feline fight club advice.
The jury, you must find for these drug offenses that Mr. Williams knew that it was cocaine and knew that he possessed that cocaine. That is not in the indictment. If it's not in the indictment and you're charging as an element, there's not much of a road to climb to realize that the indictment is bad. It left out facts. If the word unlawfully is so broad, and that's what the two judges said in Tate-Drewsome, I ask for you to disagree with them. It's not binding on you. If you do that, I'm telling you, you are ending the case. Mr. Williams is walking out. So I'm telling you that. Now the state obviously has the right to appeal, but it's double jeopardy. The jury's here. This is a great.
Okay, there it is. Yes. If the judge chooses to accept this motion to dismiss from the defense, then it's done. No trial. And I don't expect the judge to do that, not this far into the litigation and so close to the trial start.
Great issue for Mr. If God forbid I was charged with crimes, I'd want this indictment because it's fatal. And I don't know, I had nothing to do with it, but the grand jury should be taken to task if they want to bring a good case in Fulton County. And the last one is the same thing, Your Honor. It's the same exact issue. It just deals with possession of a firearm within the confines of the marijuana with intent to distribute, possession of codeine with intent to distribute, possession of cocaine. That also has the knowledge requirements. And then the same as 62, possession of a machine gun. You have to knowingly possess the gun with the converter switch and the extended magazine. The state did not allege that either. They have failed to assert a material element in the indictment. I wish to answer all your questions That is it. Mr. Floyd is a tremendous advocate and an honorable man, but his reasons are wrong. And he's just going to take up the mantle for the state and take Jerusalem, which is not binding on anyone, but he could never, ever get around the fact that this honorable court will be charging on elements not including indictment. That's what the indictment needs. Mr. Williams can admit every essential element.
I don't disagree, MG Law. Judge can save a lot of time and a lot of taxpayer money by dismissing invalid charges, make the state do things the right way, and dismiss every time they fail to do so. Yeah, but Friday, I think, or Thursday, or whatever day it was, we watched the defense arguing against the latest additions of witnesses in this trial. Because between September and November, they added 105 new witnesses, making the total amount of witnesses in this trial from the state alone to 737 witnesses. Around 50% expert witnesses and 50% layman witnesses. This is the trial with 3 billion witnesses. And the judge said to the defense that he will not dismiss any of the state's witnesses, but he will make time for the defense to interview the witnesses. I agree, MG Law. It's BS. Because when the state said they were ready for trial in November of last year, they had 79 witnesses when they said we are ready for trial. And that's why jury selection started in January and all of that things. And now a year later, they have 10 times the amount of witnesses all of a sudden. And this judge does nothing to keep this trial compact. Why, Mads asked, why not just have a normal trial? Because they don't, in everything that they allege happened in the YSL-gang between 2012 and 2021, these are the things they couldn't get charges for. Some of the then prosecutors says we don't have enough to bring charges. But all of a sudden, everything is clumped together under the RICO Act, and by sheer volume, they are prosecuting the entire gang for every little conduct they have alleged to have done, even though they've never been able to charge the crimes separately. That's why I think this is complete bull crap, this entire RICO trial. It's just a way for the state to get around due process, to get around, to get in evidence that wasn't enough for the individual crimes. MG Law says, not like the state can claim these witnesses were unable to be discovered last year. The judge should have denied every one of them. Yeah, this is something they talked about in the last stream, that the defense said, we have no way of conducting interviews with these people before the trial starts. And the judge's solution, you can interview them during the trial. And that's bull crap. How can you have a defense strategy when you don't know what the state will bring? I mean, they still haven't gotten all of the discovery. In October 15th, I believe it was, the state gave the defense the discovery of the social media accounts, the Twitter, the Instagram, the whatevers. And it is in that discovery is over 2 million entries in that discovery. And they got it a month and a half before trial starts. And it was allowed by the judge. The judge has been whining towards the state for months about get them the discovery. And the state says, oh, this, oh, that, this and that. And I don't think they have gotten all of the discovery yet, a week before the trial starts. It's mind-blowingly bad.
Of this indictment say, I admit everything, and he is not guilty of a crime. I ask the court to grant it. If you don't grant it, Your Honor, then I ask that you can just please decide to write the order and
The Georgia RICO Act has never been appealed outside of Georgia. It has been reaffirmed by the Georgia Supreme Court, but it's never been affirmed outside of Georgia.
oppose the order because I believe I'm correct that I can appeal it during our trial. I will not hold up our trial. We'll do openings, we'll do everything. But this case will go up expedited. I will explain to the appellate court, we are on trial. It's a double jeopardy case. Take it, they may not, they may just put it, it's direct appeal, it's a final order denying a plea and bar, so they'll put it in the queue. I would hope they put it, I have no idea if they'll expedite it, but within, 5-8 months, we will have a decision, we'll still be on trial. I want to thank the court. If you don't have any other questions, otherwise, as always, Your Honor, thank you so much.
Okay, thank you, sir.
All right, that was the defense argument. Now up to the state to reply to it. And I will, let's do one of these. I haven't done one of these in a long time. It's a swoop. Yay, it's a swoop. Let's do one of these as well. What time is it? What time is it? It is grifting time. Yes. What's going on with grifting time? It is me asking you to please share with you your hard-earned money so I can keep this channel afloat. Either by memberships, $3 a month, or the new tier, $6 a month. I just added it. I have no idea what else I can bring you because the $3 tier you can do more or less everything. That's just if you want to share a bit more. And the occasional super chat, I don't mind. You have my PayPal if you don't want to give YouTube a 30-40% cut. PayPal has a 5% cut. So that will bring me a bit extra. And that because you like me, you like my content, and you want to keep me afloat and keep doing this and developing the channel and stuff like I'm Swedish. This grifting is not in my nature, but not every stream can be a drinking stream, I guess. Well, that was my grifting time. And back to that. Thank you. And let's get back to this. Yeah, I gotta feed Mr. Jingles. If you don't want, if you say on the PayPal, write Jingles in the message, and it will go towards toys and treats for Jingles. Oh, I need to protect my liver at least a few days of the week. All the men out there, stop doing comb overs. It's not working.
Good morning, Your Honor.
Hi, good morning, Mr. Ford.
So I did not have, prior to this, the advantage of the cases that Mr. Steele has cited. His motion cites no cases regarding count one.
Yes, it did. I heard him quote a few cases regarding count one, but it's the state.
However, the fact of the matter is that he is incorrect on his argument. I'm going to argue with regard to count one. And let me walk through that. The indictment charges that the defendants unlawfully conspired. The governing law makes it abundantly clear.
Thank you so much, Danny T, for your $5 super chat. Thanks. Love your stream. Thank you. Thank you so much. Thank you. Thank you. I need one of these toot things that everybody else does. I have this. Super chat. Oh, crazy by proxy. Need to come up with Mr. Jingles merch. Ooh. I will try to do that tomorrow before my stream and get some Jingles stuff out there. Good idea. Thank you so much. Everybody loves cats. No? Yeah. Oh, God. Here's the dirty old man me. Jingles on knickers. Oh, that's so bad. I apologize.
That is sufficient. In this particular context, they were charged with conspiring to violate 1614(4)(a), a crime, and 1614(4)(b), a crime. So we have two layers. They have a criminal objective, and they committed a crime by conspiring to do so. Notably, only 3, I believe, of the cases cited by Mr. Steele were RICO cases. He did not cite the governing cases. I will distinguish his and lay out the ones that we believe are controlling. Beginning with that is Evans. That is Evans versus State. It is 360 Georgia Appeals 596. On page 612, the court expressly rejected the argument that specific intent to violate the law is an element of a RICO conspiracy, and that the trial court erred in failing to charge the jury on this specific intent requirement. Evans is not a 2-1 decision. It is not on cert. It is a 2021 RICO conspiracy case. It is directly on point. It is binding on this court. That, candidly, is the end of that. The Evans is itself consistent with the Supreme Court's ruling in Dorsey and a host of cases cited in Dorsey. Dorsey is 279, Georgia at 534. At 540, the Supreme Court makes it clear that a RICO violation, he was talking substantive there, requires only 2 acts of racketeering activity. And here I should point out, Your Honor, Mr. Steele spoke as if acts of racketeering activity themselves have no mens rea requirement, and as though, therefore, that RICO somehow functions on its own without any mens rea requirement, and that you have to read it in, and you have to read it in not only as a requirement of the statute, but as a requirement of an indictment. There is no Georgia support for that whatsoever, none. Dorsey makes it abundantly clear that if two related acts are proven, that is sufficient to support the indictment. That is sufficient to support a conviction. This issue is not a new one. In the 11th Circuit rejected this argument in United States versus Pepe in 1984. In that case, and speaking of jury instructions.
How do you spell Pepe?
I'm sorry, Papa Echo.
Okay.
In that case, speaking of jury instructions, the challenge was that the district court erred in declining to instruct the jury that participation in the enterprise's affairs had to be knowing and willful. The court rejected that. Without these elements of mens rea and Siena appellant's claim, RICO would become a strict liability measure. Sound familiar? The 11th Circuit said, we disagree. They had already decided this in a case called Diecidu, D-I-E-C-I.
Welcome to the Georgia RICO Act. It's so vague and so broad. Apparently, they don't have to show intent. Seriously. How can you have a conspiracy without intent? This would mean that you could be unknowingly be in a conspiracy just by taking something there and move it over here. You don't know what it is or why you're doing it, just that you get paid for doing it. That would put every postal officer in jeopardy. This is why RICO, because I've heard a lot of lawyers from Georgia, not a lot of lawyers, a few lawyers from Georgia talk and write about the Georgia RICO Act being so broad and so vague, it's ridiculous. And here you have it. The RICO charge doesn't need intent.
IDUE. It's at 603 F second, and specifically the pin site was 548 there. We rejected this contention. A plain reading of the statute indicates that RICO does not contain any separate mens rea or Siena requirements beyond those encompassed in its predicate acts. I was quoting Pepe there at 675 and 676. In this regard, there's no material difference between the Georgia statute and RICO. They both use unlawfully. It's the same formulation. Other federal courts long ago disposed of this argument. An example is United States versus BAFA, Bravo, Oscar, Foxtrot, Alpha, 513 F Sup 444, in which the court observed that RICO does not itself contain an express intent requirement over and above that required by the individual crimes. Consequently, no specific intent to engage in an unlawful pattern of racketeering activity prohibited by RICO necessarily need be alleged in an indictment. Similarly, the Second Circuit in Boylan, also in 1980, 620 F Second 359. Boylan is spelled Bravo, Oscar, Yankee, Lima, Alpha, November. I quote from page 361 and 362. RICO count does not include a cyanide element over and above that required by the predicate crimes. And the Second Circuit, also in 1980, in United States versus Scotto, Sierra, Charlie, Oscar, Tango, Tango, Oscar, 641 at second 47 excuse me, 56. Again, a case in which the defendant argued that a willfulness instruction should have been given to the jury. The law at issue here does not demand willful violations of the RICO statute, the Second Circuit concluded, nor does it require willful violations of the predicate offenses. Here, as in Boylan, which I just referred to, we think the court's charge was favorable to the defendant because it permitted conviction only if the jury found a criminal motive or purpose. Even the cases cited by Scotto do not require as much. So there, the trial court actually sort of overshot the mark and gave a more demanding instruction than the statute required. But the court went on to say, it went on to observe that RICO has no separate mens rea requirement. And I quote, "We have no reason to believe, however, from the words of the statute or from general criminal law doctrine, that the quantum of mens rea required for a RICO conspiracy conviction should be different from or greater than that required for a substantive RICO offense." So these are the actual RICO cases that have actually dealt with this issue. What Mr. Steele is doing is attempting to tease out of the dissent in State Gesserum a rule.
Yes, MG Law. So those predicate crimes, yeah, no knowledge or intent. I mean, it's so insanely stupid. That's the Georgia RICO Act. And that's why Mr. Trump might be in more trouble than we think. What is a Swedish thing? According to the state, the Georgia RICO Act does not need intent. Imagine how much yelling I will do once the trial starts, because I have knowledge of all of this. You, my regular viewers, have knowledge of all of this, and if if the viewer count goes up once the trial actually starts, people will start to wonder, why is Nick yelling so much? And you all can help me explain to all the hopefully new viewers why I'm yelling.
Trying to get you to follow it. Tate Gesserum is not a new novel case. Its ruling was basically that unlawfully was sufficient to track the requirement of mens rea. It cited prior Georgia Supreme Court cases. To hear Mr. Steele argue it, you would think that this fell out of the sky. One of the cases that are cited is Humphrey versus State, 231, Georgia 855 and 861, a 1974 case, all right, which held that the allegation of criminal intent is necessarily inferred from an indictment that charges an offense in the language of the statute and alleges it was committed unlawfully. That is exactly what the state did here. Charged in the language of the offense and alleged that the conduct was engaged in unlawfully. Other Georgia cases, not limited to physical precedent, not with a dissent, include, and this one is a bit of a mouthful, I apologize, Stevo-Stianova, Sierra Echo Victor Oscar Sierra Tango India Yankee Alpha November Oscar Victor Alpha versus State, 313 Georgia App 729, a 2012 Georgia Court of Appeals case, no dissent, said that the term unlawfully in the accusation with reference to the appropriate code section sufficiently included the intent to commit the criminal act and the knowledge necessary to form such intent. Appellant could not admit the allegations of count one and remain innocent of the charge alleged therein, thus a general demur to the accusation would not lie. Those last two sentences are fully applicable here. Again, a 2012 decision. It's not just that Tate Jassem is a majority case, it's that Tate Jassem reflects a long-standing body of Georgia law. Another example is State versus Meadows, 252 Georgia Appeals at 376. It said that use of the word unlawfully instead of the word knowingly was sufficient to charge the defendant, in that case, with committing arson with the requisite intent. There it was citing a case called Frost v. State, 200 Georgia Appeals at 267. In Meadows itself, the court said similarly, in this case, the use of the word unlawfully was proper in charging Meadows with 2 counts of simple battery. This is not new law. This is not controversial law. This is not uncertain law. I mentioned Humphrey previously, the Georgia Supreme Court decision from 1974. The quote there at page 231, Georgia at 861, the present indictment charges this offense in the language of the statute and alleges it was committed unlawfully, from which allegation the criminal intent is necessarily referred. And Humphrey itself was not new. It cites 2 rather old Georgia, an older Georgia Supreme Court and an older Georgia Court of Appeals case. Again, not new law, not controversial law. That takes us to the cases cited by Mr. Steele. State v. Heath, not a RICO. Heath v. State, not a RICO. Jassem, he relies on the dissent. Rowan is a United States Supreme Court case. It's decided under Title 21. It was a case involving the conviction of physicians for the unlawful distribution of controlled substances. Dealt with the adequacy of proof at trial, not a challenge to an indictment. And it's materially different because unlike Mr. Williams on these drug charges, these doctors could have lawfully distributed controlled substances if they had written a valid prescription. And the question was on a specific provision of a code of federal regulations that dealt with what makes a facially valid prescription unlawful. And it had a specific intent provision in that. It's a fundamental.
With all the wordings about unlawful, it seems like Mr. Brooks would have a better defense in Georgia if they claim that unlawful is a good word to use.
Totally different case. Alanis is not a RICO. The cases that are cited that were RICOs, MacArthur is a civil case. Cotman arose out of the APS cheating scandal. I was on that case. Wiley was another criminal case. Each one cites, these were cited for the quotation of a description of the elements of RICO conspiracy that included knowingly and willfully. But every one of those traces back to a federal district court case. That federal district court case was Rosen versus Protective Life Insurance Company, 817 F sub 2nd 1357 at 1382. That was a summary judgment issued by Judge Duffy. I remember it because I was on the wrong side of that summary judgment. I represented the plaintiff in that case. But that's Judge Duffy's formulation of it for purposes of deciding a summary judgment, he injected the words knowingly and willfully in there. Other Georgia courts have picked it up, quoting generally the elements of this, but there is no knowingly and willfully requirement in the statute. This is not anything that has ever been used to dismiss an indictment. That language is superfluous. The fact that it's been quoted does not mean it's been decided. Two very, very different things. Similarly, the citation to the Trump case, where out of an abundance of caution on page 14, the state did reference knowingly and willfully joining a conspiracy. The fact that we did that in that indictment doesn't make it an element, doesn't make it a requirement in other.
Interesting. So the state says, we don't have to use the same language, the same legal language in our RICO indictments. Why should we? It's a different indictment. Just because we were more careful against Trump doesn't mean we have to be careful here. What a bullshit argument. What a complete bullshit argument. The law and procedures should be equal to all. Just by admitting you were more careful about the language against Trump shows you were bad at the language in this one because you couldn't be bothered with it.
Indictments. In fact, we have evidence which says quite clearly it's not. In fact, we have Pepe, Bafa, Scotto, and others that say it's not. And so the idea here that we're going to create an additional requirement that exists nowhere in Georgia law has been rejected by Georgia courts, specifically in the context of RICO. That the idea that unlawfully is insufficient, that has been specifically rejected by the Georgia Supreme Court and the Georgia Court of Appeals on multiple occasions. There's no room to maneuver there. It just doesn't give you an option, Your Honor. And on top of that, were there any doubt, federal courts interpreting the same language in the federal statute, counterpart language there, in an area where, although there are significant differences between the two statutes, here, on this point, relevant to what you're deciding now, there are none. The word is unlawfully in both. Those courts have all reached the same conclusion that Evans reached, which is this is not a requirement for a charging document, not actually a requirement for jury charges either. Mr. Steele has not given you what you would expect here, which is a single RICO case from anywhere in the country that says the absence of knowing and intentional in the charging document requires its dismissal. There is no such federal case. There is no such Georgia case. This would be the first one of which I've been aware. So if the court has any questions, happy to address them. Otherwise,
yeah, this is a Georgia state prosecution. It's the same prosecutor as in the Trump case. Fannie Love, or whatever her name is. Is her name Fannie Love? No. Fannie Willis. Sorry, Fannie Willis. Willful Fannie. Yeah, this is a Georgia state prosecution.
I'll turn it over to Mr. Uleski, who's going to deal with the other counts.
Okay. All right.
Thank you.
Okay. This, please, one horse, one rider. One horse, one rider. So first one of the prosecution members shows up, and then here comes guy number two.
May it please the court, Your Honor. Same as with the RICO discussion, there's been provided no case law that says as to gang counts, particularly 56, 57, that the absence of the words knowingly, these magic words knowingly and or intentionally requires dismissal subject to a general demurrer. Instead, when you look to counts 56 and 57, you'll note that 56 is under Gang Act Section D, 57 is under Gang Act Section A. Going to 16, 15, 4 in those particular subdivisions, there's no specific intent required in the language of either A or D, which 56 and 57 ride upon. Whereas you do see intent in subsection B and F and stuff like that, you don't see it in A or D, which is alleged in this indictment properly. And more than that, the discussion of how the word, knowingly and willfully, that's sufficient, right? But pursuant to all this authority we've been talking about, so is unlawfully when it tracks the language of the statute, which counts 56 and 57 both do. And I'll point out that 57, in fact, says that, on so-and-so day, the accused did unlawfully, and then it tracks the language of the statute. And then in 56, it tracks the exact language of the statute. And I'll point out that the verb conspire is included in there, which there's some discussion, including the Black's Law Dictionary discussion, about how it's not really conceptually possible to accidentally or sort of negligently conspire to do something. So I would argue that mens rea is sufficiently alleged, both in 56 and 57. And on top of all that, 56 and 57 both say at the end that this was done, these verbs were done contrary to the laws of the state. So
if you want to go back and watch my streams about the Daubert hearings, when they try to admit experts, and holy cow, the state has some horrible experts. Complete bullcrap experts. The pinch and zoom guy, who the state wanted they wanted an expert in forensic video analysis. And once so they brought him up to the stand, prosecution interviewed him, and during cross-examination by the defense, they managed to get it out of him. The only thing he does for the police, he pauses the video, he takes a screenshot, move it over to Photoshop, and enhances the part the cops want enhanced. Pinch and zoom. That's the guy the prosecution team wanted in as a forensic video analyst. He didn't get in as a forensic video analyst. He got in as a video enhancement expert. My 5-year-old niece knows more about video enhancing than that moron. That's the level of complete and utter garbage the prosecution team is moving in as evidence and expert witnesses in this trial.
They got unlawfully on both of those counts. Those are as to the Gang Act counts. And I will go forward and talk about the other counts as well. Going to 58 and 59, all the same discussion that we've had applies. It says unlawfully in both of those counts. It tracks the language of the statute. On top of that, though, it does say with intent to distribute. It literally says the intent in 58. And 59 literally says with intent to distribute. It literally charges the mens rea. 60, 61, and 62 all track the language of the statute.
Yeah, the separate charges, yes, but the overall charge is under the RICO Act. If you want to charge them separately for the separate crimes, then do that. But you didn't, because you didn't have enough evidence in the original act, in the original crime against the different defendants in this trial. But you brought it all in under the RICO Act umbrella, which is so broad and so vague. Yeah. Yeah, the gang task force guy. Oh, yeah.
They all include the adverb unlawfully. And for the argument to be made that, well, Brooks applies because, the charging instructions to the jury need to allege, that it was knowingly and willfully or what have you. As echoing Mr. Floyd, that analysis is incorrect because, Brooks is to do with the evidence at trial and what the jury is charged on after having heard the evidence at trial, including any defenses that may be raised. So for example, I got an indictment and it says somebody did something unlawfully, right? Well, let's say somebody raises a defense of accident or mistake of fact or something like that. Well, of course, after the evidence is out, you're going to have to charge the jury relevant to those defenses, right? So the same as Mr. Williams has told us that he's going to raise lack of knowledge on these, well, then maybe there is going to be a charging instrument later on after evidence is in that has to do with knowledge. But we're not into evidence. There was no general demur raised in Rooks. It's inapplicable. It's inapposite. And to strike any of these counts on this basis is really to confuse what in logic is called like a sufficient versus a necessary condition. It's not necessary that every count has the word, these magic words, knowingly, willfully. Unlawfully is enough when it tracks the language of the statute, and that applies to 56, 57, 58, 59, 60, 61, and 62. Mr. Floyd and I would be happy to address any questions, but at this time, with your honor's permission, I'll conclude.
Okay.
Thank you.
Do you have a reply, defense attorney? You know what? It's time. Come on.
Council, I'm going to take a
Okay. Taking a break. And skipping ahead a bit. That's Mr. Youngstock, by the way. Oh, yes. Swoop. Yay. And for you who don't know what this is, that's my Norwegian fire-farting dragon. Come on.
And kind of talk about where we are for the rest of the remainder of the afternoon. The court's had an opportunity to consider the defendant's plea and bar motion to dismiss General Demur filed on behalf of Jeffrey Williams. Courts also had an opportunity to consider the state's response in opposition to defendant Jeffrey Williams. Court's also taken a look at the indictment filed in this case as it appears under 22 SC 183572. Court's also considered State versus Heath, citations which have already been set forth on the record. Ron, and that is X-ray India, uniform Lima, uniform Ruan, Romeo, uniform Alpha November versus United States. Elanis versus United States, MacArthur versus Beach Haven Baptist Church of Atlanta, Cotman versus the state, Wiley, that's Whiskey, Yankee, Lima, India, Echo versus Denton, Rooks versus the state, and Tate, Jeshurun, and that's Juliet, Echo, Sierra, uniform Romeo, uniform Mike, Tate versus Jeshurun versus the state. Tate, I should say, hyphen Jeshurun versus the state. The court's also considered the following other cases as well, and that's Evans versus the state, which has already been cited by counsel. United States versus Pepe, cited by counsel. United States versus Boffa, cited by counsel. United States versus Scotto, cited by counsel. Rooks versus the state, also cited by counsel. after consideration and of reading these particular cases and hearing the arguments of counsel and reading the motions that were filed for to therein and the responses in the plea and bar and motion to dismiss General Demur, the court is of the opinion that pursuant to Pepe Buffo and Scotto, that a consideration, among other cases, in consideration of the elements of knowingly and willfully are not required. Our case law at this point in time, unlawfully is sufficient, and it tracks, and I find that the state's indictment tracks the language of the statute and is sufficient. Therein for counts 1, 56, 57, 58, 59, and 60, 61, and 62, as it pertains to the state versus Mr. Jeffrey Williams. For those reasons, the court is going to deny the defendant's plea and bar motion to dismiss General Demur. Mr. Floyd, if you will prepare a suitable order for my signature, submit that for Mr. Steele's consideration. I'll go ahead and file it, and he can take whatever other steps that he feels necessary on behalf of his client at this point in time to go ahead and do that. I don't know if he'll be able to take a direct appeal. I think he probably can, but that won't stop this trial of the matter.
Understood, Your Honor.
So,
Thank you.
all right, if you could get, when do you believe you could get that done? You already owe me some homework for today, but when do you think?
That's in process.
I know, sir. I know, sir.
We'll get that today.
You think, what, a week?
This is end of business tomorrow sufficient. Your
That
Honor.
would be more than sufficient.
Okay.
Okay.
Thank you.
All right, that'd be more than sufficient.
The
All
defense,
right,
the defense said already in their argument that if the court would deny the deny the motion, they would appeal more or less immediately. And if the higher court deems that the appeal is good, the motion is good, well, then the trial stops, more or less, mid-trial. But as you all know, appeal are for losers. Ow!
okay, Mr. Uhelski, one of your colleagues, when this will be back? Because I believe they have, unless you have some other,
I need shoulder
I
pads.
believe we're supposed to review the witness list. There's a motion to disqualify Mr. Steele. There is a continuation on a motion to suppress Nichols 17 and 18.
Yeah.
Is that correct?
That's correct. According to my records. I'm not quite sure when there will be.
Okay.
I don't want to represent otherwise.
All right,
Edge crashed. Edge crashed for me. So, okay. That was interesting. Tried to restart Edge, didn't work. So I'm at, I'm at Chrome. Okay, now, Gino, stop using your claws. Yeah. I will try try to find everything again so we can. Dun dun dun. Oh. Try to find where we were. Okay, found it. Share screen. Share screen. Sound. Add to stage. There we are. All right. Kitty is displeased. Yeah. I love my cat, but he can be such an asshole. Yeah. Fine interlocutory. Oh, they won't have a hearing in higher court before. Their trial starts on Monday. So, no. So if they will file to a higher court, the Georgia Appellate Court, and if the Georgia Appellate Court says, yes, your motion should have been approved, trial's over, mid-trial. My light is making me look orange. I'm half Trump. Hold on. Is this better? Okay, let's continue.
And
Chrome doesn't break up for me.
and Scotto, that a consideration, among other cases, in consideration of the elements of knowingly and willfully are not required. Our case law at this point in time, unlawfully is sufficient, and it tracks, and I find that
Okay, we already know
58 as a reason, Mr. Steele's consideration. I'll go ahead and file it, and he can take whatever other steps that he feels necessary on behalf of his client at this point in time to go ahead and do that. I don't know if he'll be able to take a direct appeal. I think he probably can, but that won't stop this trial of the matter.
Understood, Your Honor. Thank you.
All right, if you could get, when do you believe you could get that done? You already owe me some homework for today, but when do you think?
That's in process.
I know, sir. I know, sir.
We'll get that today.
You think, what, a week?
This is end of business tomorrow sufficient. Your
That
Honor.
would be more than sufficient.
Okay,
Okay.
thank you.
All right, that'd be more than sufficient. All right. Okay, Mr. Uhelski, when are your colleagues, when this will be back?
Are you excited?
Because I believe they have, unless you have some other, I believe we're supposed to review the witness list.
Oh,
There are
witness
some,
list.
there's a motion to disqualify Mr. Steele. There is a continuation on a motion to suppress Nichols 17 and 18.
Yeah.
Is that correct?
That's correct. Please, my records. I'm not quite sure when there will be.
Okay.
I don't want to represent otherwise.
All right, I'm gonna come back at 1 o'clock, okay? Mr. Steele, as I understand it, you're supposed to be in front of my colleague Judge Ingram at 2?
I told the Honorable Judge Ingram now with you, but, I'll do that on top of the vote.
Okay, so they will have a break. So I will push forward till they come back. And they're back.
No, I'm with, my pledge is with you. I'm staying with you. So if you don't know this, the other case is Mr. Blaylock. I represent him on appeal. He's a co-indictee here. Mr. Ryan, he's present in your honorable courtroom. He's represented by a different person on appeal from the same case. They were co-defendants in a murder case. They both were government convicted, so they both appealed. Ms. D. Williams is not the appellate lawyer for that case. I have already done everything for Mr. Blaylock. So it's really not me. If I go to the Honorable Judge Ingram, I will do what you tell me to do, and I will sit there. If something comes up, of course, I'll adopt it. It's the co-defendant who needs Mr. Ryan, co-defendant's appellate lawyer needs Mr. Ryan, because they are calling, I believe, and please understand, I may be wrong, but they're calling the trial lawyer for testimony, and they're calling 3 alibi witnesses that were not called to trial. I have no idea how long that's going to be.
That
I'm
would
just
be
going to sit
interesting
there.
to cover.
If something comes up that, for Mr. Blaylock, I'll of course argue it and adopt it. So I'm sure that's why the Honorable Judge Ingram summoned me. But otherwise, your Honorable Court, if you remember months ago, allowed me to do that hearing. I did my hearing. The other side asked for a continuance. They were not ready with witnesses. So to answer your question along the way, I'm just with you. I believe, though, I don't want to overstep my bounds. You didn't ask this. I believe Mr. Ryan needs to go. He's really the
Hi,
issue,
Rob Mill.
the way I understand it.
See you.
Yeah, I can ask for, is that correct?
Yes, Your Honor, that's correct. I have been speaking with his appellate attorney to find out how many witnesses and about how long he thinks it'll take today.
Okay.
This
All right.
isn't- Hello.
Thank you now. At least take 15 minutes. If you could let me know, Mr. Yelsey, back, and if that's the case. So.
Okay. They are taking another break.
Reorganize the count for the items. I think it was supposed to that. He's supposed to
They return.
finish on 17 and 18.
Yeah, we'll be prepared with,
Yeah, this-
I'll give you up to the minute.
Judge is known for taking really long breaks.
Today.
Jesus Christ.
Plan, hopefully today. But I need to, there's some other business who wants to pick up, and then everyone will be here more. I could do it tomorrow, but I'm gonna try and do it more, just housekeeping. Okay, I think we do.
We are almost
All
up
right,
to the actual live. I started 5 hours after this hearing started, and the amount of breaks puts me almost up to live. Oh my God. That would be a hearing day with almost 3 hours of breaks for this judge. Oh.
Ms. Love and Ms. Hilton, first, good day. I hadn't seen you all day long. You've been taking care of other business, I understand.
Yes, Your
So first time to greet you, ladies. All right, so got a couple of things. Are you all prepared to deal with motion to suppress 17 and 18 for Mr. Nichols?
Yes, Your Honor.
Okay, all right. Do you have your witnesses here?
Yes.
All right, call your first witness.
Okay. We have a witness hearing.
It'll be Sergeant Maldonado, Maldando.
By the way, if we reach $50 in gifted memberships and super chats, I will take a shot because I am free tomorrow. Yay!
Your Honor, as Sergeant Maldonado is coming in, just want to kind of frame what's going on with the for both of these hearings today. Your Honor, this is Mr. Nichols' motion suppressed for two separate instances, Your Honor. The first is a July 3rd, 2017 incident in which Mr. Nichols seeks to suppress drugs and a gun found during a search of a vehicle for which he
I have jingles here again. I will find a sports jacket with shoulder pads so he can step on my shoulders without me screaming out loud. Keep listening to Ms. Love here.
He was an unlicensed driver. It had 4 outstanding warrants, and the owner of the vehicle, who was the passenger, gave consent to search the vehicle. Mr. Nichols subsequently pled to these charges. He pled to possession with intent to distribute, narcotics, possession of a firearm by a convicted felon, possession and use of drug-related objects, drugs not in original container, which was a misdemeanor, driving without a valid license. In all of this, he pled under indictment 17 SC 153307. He received a sentence of 10 years to serve, 2 years balanced on probation, and he got that sentence in March of 2018. In October 2018, while he was on probation for the 17 SC case, Mr. Nichols was then again arrested and charged with possession of marijuana with intent to distribute, possession of a firearm during the commission of a felony for 3 guns that were in a car in which the state contends that he abandoned. He was charged with possession of a firearm by a convicted felon for those same 3 guns. In 2019, Mr. Nichols did file a motion to suppress the drugs in that case, which the state believes was subsequently abandoned because the defendant pled to the facts in that case. He pled to a reduced charge of disorderly conduct for the marijuana and pled to possession of a firearm by a convicted felon. So we're here on a motion to suppress for those 2 incidents. Your Honor, as to both, we do have witnesses present to be heard. We do believe in the 2018 case, Mr. Nichols lacks standing to challenge the search of that vehicle. We will.
So they pled out to a misdemeanor. The separate. For me, that says, okay, they pled out to the misdemeanor. Why are those charges still in this RICO charge? If they already have conviction done. I don't get it, but
We'll ask to address that after we present the first witness in that case. We'll ask to address the standard issue before we call the second witness. But we will start with the 2017 incident.
Okay, all right. I'll call you first. Sergeant
Maldonado.
Sergeant Maldonado, good afternoon. Sir, if you would please approach the witness stand. Before you get there, if you would turn and face Sergeant Ingram and be sworn as a witness, please.
Raise your right hand. You swear firm testimony you give today, truth, whole truth, nothing but the truth. I do. Have a seat. State is spelling the first and last name for the court. So
Sure. I'm Sergeant Carlos Maldonado. Carlos is Carlos. Last name is Maldonado.
And Sergeant Maldonado, where are you employed?
I'm currently employed with the City of Atlanta Police Department.
And how long have you been with the City of Atlanta Police Department?
For 11 years.
And what is your current position?
I'm currently assigned as a supervisor for the aggravated assault unit, and I'm a task force officer with the Federal Bureau of Alcohol, Tobacco, Firearms, and Explosives.
How long have you served in your current assignment?
I've been with the aggravated assault unit since the summer of 2021, and I've been with ATF since September of last year.
Prior to your current assignment as a sergeant in the Ag Assault Unit, where were you employed?
I was with the Zone 4 Field Investigations Team, assigned as a supervisor.
And if you could tell the court a little what you do as a Zone 4 Field Investigation Team and as a supervisor.
Sure. So the FIT team also is called the Crime Suppression Unit. Their names are interchangeable between the two. Each zone has a FIT team whose job basically is to look at crime trends in certain areas and patrol those specific areas in order to combat whatever the current crime trend is. They work in both uniform capacity, wearing uniforms and driving marked vehicles, as well as working undercover assignments in regular clothes, driving regular cars, observing crime, and using marked vehicles as units to make contact with whatever it is that they observe to initiate a stop and complete an investigation with.
And in 2017, were you assigned with the FIT team?
I was, as an officer.
Okay. And in 2017, what zone were you assigned to?
To Zone 4.
And where's Zone 4?
Zone 4 encompasses the southwest Atlanta portion of the city. It goes all the way from the west end of Atlanta to Camp Creek Parkway. And to the west, it borders up against the city of South Fulton and goes all the way to the eastern border of Lee Street, where it turns into Zone 3.
Okay. I want to direct your attention to July 3rd, 2017. Did you have the occasion to participate in a search of a vehicle in Zone 4 as an officer with the FIT team?
I did.
What brought you to Zone 4 that day?
Sure, that was a regular assignment. That particular time, we were trying to combat an area that was seeing an uptick in robberies. So we were patrolling in the 700 block of...
I took it down a bit because it's hurting my ears. If you think it's too low, I will adjust.
Cascade Road, which had seen an increase in robberies in the previous days leading up to that day.
Were there other officers with you that day?
Sure, I was riding in a vehicle with Officer Travis Owen. Travis is spelled Travis, and Owen is Owen. And then there was a separate vehicle, which was occupied by 4 officers. It would have been an Officer Mayfield. It's Mayfield. Officer Rhodes, Rhodes. Officer Chisholm, Chisolm, and I believe there's just 3 of them in that vehicle.
Okay. And while on patrol, did you have the occasion to stop a 2016 Volkswagen?
We did.
Okay. Can you describe the car for the court? Sure.
We were patrolling in front of an apartment complex, which is located at 763 Cascade Avenue, which was in that particular area, which we were directed to patrol. We observed a vehicle that was exiting the apartment complex and entered onto the city street of Cascade Avenue. The vehicle had extremely heavy tint. We could not see the occupants inside that vehicle. We followed the vehicle until it came to the next major intersection, which was Cascade and Donnelly Avenue. The vehicle pulled into the Checkers restaurant into the drive-thru, and we initiated a traffic stop as it was in the drive-thru.
What happened when you initiated the traffic stop?
So we walked into the vehicle. We made instructions to the officers or to the occupants of the vehicle to lower the windows because it was extremely heavy tint and we could not see inside of the vehicle. And the door was open slightly ajar, and they stated that they could not lower the windows because it was fresh tint that was just installed on the window.
You said they. Was it someone specifically who spoke to you?
It was the driver of the vehicle.
And how many occupants were inside of the vehicle?
There were 5 people inside of the vehicle. There were 3 males and a female and a baby.
Once the driver opened the door because they could not wind down the window, what happened next?
We asked the driver for his driver's license, and he said he did not have one.
Once the driver said that he did not have a license, what happened next?
We had him step out, and Officer Owen detained him until we could figure out more information about him and who he was.
Okay. And were you able to figure out more information?
We were.
What were you able to determine?
We identified the driver as Mr. Kumarbius Nichols. I would have to refer back to my report for the exact spelling of his name. And then we discovered, after running an inquiry in our in-car computer, that Mr. Nichols was not licensed to operate a motor vehicle in the state of Georgia.
Okay. Once you were able to determine that Mr. Nichols was unlicensed to drive, what happened with the other occupants of the vehicle?
Sure. As we were checking our computer to check the information for Mr. Nichols, Officer Chisholm was speaking to a female who was in the front passenger seat. That was Miss Pierre, who was actually the registered owner of the vehicle, and she had her step out, and they were talking away from the vehicle.
Okay. Could you see them talking to each other?
I can't recall from my position if I saw them or not.
Once they finished talking, what happened next?
Officer Chisholm came back and stated that the female, Miss Pierre, had given consent for us to search the vehicle.
Okay. And after you were given the consent, did you all search the vehicle?
We did.
What, if anything, did you find?
Sure, we located a loaded Taurus 9mm handgun, which was underneath the driver's seat, which would have been directly underneath Mr. Nichols, and also at the feet of the rear passenger, who I believe is Mr. Brandon Warren.
Okay.
Yeah, I know the mic, but if I lower it, we can't hear her. So it's swingabouts and carousels or whatever it's called. I can't do anything about it. And as Ashton says, I do not give legal advice. I have a law degree, but I cannot give any legal advice to people who aren't my clients. And I don't have a US law degree, so whatever I say, you cannot apply it to US laws anyway. But that's a good general advice, is to shut the F up and do not consent. That's not legal advice. That's general life advice when it comes to police officers.
Did you find anything else in the vehicle?
Yes, in the center console, we located powder MDMA, as well as some Xanax pills, and in total, it weighed 47.7 grams.
After you searched the vehicle, what happened?
Sure, all occupants in the vehicle were identified, and we ran them on our in-car computer as well, and discovered that there were other occupants that had warrants. Ms. Pierre had a failure to appear warrant for a traffic violation out of the city of Atlanta, and then Mr. Nichols actually had 4 separate warrants for his arrest. One for violation of probation for criminal damage to property, an aggravated assault charge, a simple assault charge, and a burglary charge out of Florida.
And did anyone make claim to any of the drugs or gun in the vehicle?
No, we actually did Mirandize all the occupants. Only one person wanted to speak to us.
Ashton says, don't physically oppose, let your attorney fight, but don't give the state the right to argue they had consent. That is why even I, over here in Europe, I have a dash cam that records voices and video. That way, they cannot argue anything else. Well, they can, but then you have your voice recorded saying stuff. I can't do recommendations. I don't do legal advice. But generally, a dash cam is a good idea. For whatever reason you need it. Life advice, general advice, not legal advice.
Mr. Norman Harris, but he denied knowing of any of the items in the vehicle, as did everyone else. Everyone else did not say anything about anything that was in the vehicle and denied knowing that it was there.
Okay. And at any point in time, did you actually test the window to see if the tent was a legal tent?
I did.
And what happened?
Sure, it measured at 21%, which is below the legal limit in the state of Georgia for a sedan. It's required to be at 32%.
Okay. And let me ask, in 2017, did you all have body cam video?
Yes, we did.
And as it relates to arrest, so let me back up. Was your body cam on?
It was.
As it relates to arrest, would you still have access to those 2017 body cam videos?
Unless it was downloaded, no.
Okay. Why is that?
Sure. So every time we make an encounter with the police department, we have to classify our interaction for whatever the case may be, whether it's a general citizen encounter, an investigation, or an arrest. In this case, the footage would have been labeled as an arrest since an arrest was made. And our retention policy period for arrest videos is for 5 years, unless it's related to a capital offense or a serious offense, such as murder, a homicide by vehicle, or any sort of SVU, like a special victims related crime, which is in that period is retained for an indefinite period of time.
After you searched the vehicle and found the gun and the drugs from the center console, were those items taken to APD?
Yes, so since we operate in a team capacity, one of us would have collected all the evidence that we collected in that particular workday, and then we would have taken it down to the annex, and it would have been submitted to Atlanta Police Property.
Okay. After searching the vehicle and making all the arrests that were made, did that conclude your involvement in the case?
With this case, yes.
Court indulgent.
Okay.
Thank you. Seeing no further questions.
Good afternoon, Sergeant.
Afternoon, Harry.
Pretty good. All right, so on the day of this incident, were you in plain clothes or uniform?
Sure. So we were in plainclothes capacity, which would have been defined by a outer carrier vest that's clearly labeled with police on the front and the back, but we were operating in marked vehicles.
Okay. The marked vehicles, please tell us exactly what type of vehicle?
Sure. I would have been on in a Ford Taurus. Officer Mayfield would have been driving a Ford Explorer, but it would have been the typical Atlanta police marked vehicle, the blue background with the red lettering.
Were you driving or were you a passenger?
I was the passenger in the vehicle.
All right, at the time, you explained that field investigation team, you work on trends.
That is correct.
Correct. And the trend at this time in 2017 was for robberies, is that correct?
That is correct.
So was your primary investigation or duties to look into robberies?
No, it was to basically just be like proactive enforcement in those areas where those crimes were occurring.
And how?
Sure, by conducting person stops, suspicious person stops, vehicle stops, anything that we saw, any crimes being committed, just targeting those people. And our job was to go beyond the stop. We would stop someone, say for a violation, talk to them, see if they have any information about crimes occurring in the neighborhood, or on a vehicle stop to push forward and see if there's anything that might be inside of a vehicle.
And that was your duty on 2017 when you pulled over the car that Mr. Nichols was in?
That's correct.
Done with this.
Tell us the other officers that were with you. Did you say it was 4? I know you said 4.
Sure, so it's 2 in my vehicle since we're in the Ford Taurus. It would have been Officer Owen and myself. And then the other vehicle, the Ford Explorer, would have been Rhodes, Chisholm, and Mayfield.
Okay. So 3 officers inside the Explorer.
Correct. It didn't have a cage, so they rode either 3 or 4 deep, depending on how many people were at work that day.
What was the approximate time did you see this vehicle?
I would have to first report, but I believe it was afternoon.
Yeah, this is still a hearing about suppressing this from the indictment, and the state wants it in, of course, even though the defendant in that case have pled out to a misdemeanor. So that crime should be gone, in my opinion, from the RICO Act. That there are already convictions, but prosecutions says no, we want it in because reasons.
Now I know this was in 2017. Do you have any recollection of this incident besides what's in your report?
Right, Ashton, good to have you here.
And would your report help refresh your memory?
Sure.
Here's the thing. I'm quite sure his testimony and everything exists on paper. So why drag this one in and have a full oral hearing when everything is on paper? Submit the transcripts. Prosecution says this. Defense says this. Get a ruling. No, drag it the fuck out with bringing this guy in. For me, it's unnecessary, but it's not my courtroom. Yeah, maybe. Good point, Mads. Thank you. Yeah, the plea deal is already
Mr.
entered.
O'Sullivan, what do you want to refresh his recollection? Is that what you're trying to do?
Your Honor, I'd like to know the approximate time that he pulled over the vehicle.
Okay, all right.
So I'll ask him. Sergeant, what time did you pull over this vehicle?
Sure, the exact time, I would have to look at the report to refresh my memory, but I do recall it being afternoon.
All right, Steve, just mark it as D1 for the first motion.
Yes.
All right.
May I approach?
You may.
Thank you. And the time we pulled the vehicle was 16:37, which is 4:37 in the afternoon.
Now, you stated that you could not see inside this vehicle.
That is correct.
Okay. So you couldn't see the driver nor the passengers.
That's correct.
You've received some training in window tint and to be able, yes?
Yes, I have.
Okay. And at what tint measurement can you not see inside the vehicle? Do you know?
No, particularly, I don't have that memory.
Did you or any officer with you run the plates to this vehicle prior to pulling it over?
No.
And how long did it take from the moment that you saw the vehicle to the moment that you pulled the vehicle over?
Sure. We saw the vehicle as it exited 763 Cascade, and we would have called saying that we're about to stop this vehicle, and that's waiting for the other vehicle, which had Officer Mayfield, which is in the roads in it, to conduct a stop with us. And by that point, the vehicle had pulled in the drive-through of the Checkers, which is approximately a quarter mile away from the apartment complex.
Now, you said you would have called. Are you saying that's what you did? Or
That is what I did, yes.
So would it be fair to say less than a minute?
Approximately.
Approximately. Now, we know that you wrote a report regarding this incident. Did you write any supplemental reports?
I did not.
So as far as you remember, you only wrote one report?
The main incident report.
Is that the report that I just handed you?
It is.
Did you review that report today prior to your testimony?
Yes.
When you pulled over the vehicle, I know that you were in the Ford Taurus and you had a Ford Explorer. What vehicle was ahead of who? Were you first or was the Ford Explorer first?
We were the primary vehicle that initiated the stop. Okay.
All right, so once you initiated.
I need to have Dave or somebody explain this to me, because there is a plea deal in place with all the facts and the sentencing and everything. Why the circus? Why the circus? Why couldn't this be handled in written motions? It's a waste of time. A waste of taxpayers' money, in my opinion. Here's the transcript. Prosecution argues this should be let in. Defense says no, this should not be let in. Ruling.
Stop. The Explorer is behind you. You pull over the vehicle inside the Checkers, correct?
That is correct.
All right, and then you stepped out of your vehicle?
Correct.
And when you stepped out of your vehicle, tell me what you did.
Sure. Officer Owen approached the driver door, and I would have come up. I came up right behind him on the passenger side, and the other occupants of the vehicle would come up on the passenger side. That was a standard operating procedure for our 15 on how we stop vehicles.
Okay, so you said Officer Owen
Correct.
approached the passenger side.
No, the driver's side.
Okay, so Owen approached the driver's side, and you approached the passenger side.
No, I approached the same side of the driver's side, and I would have been at the second window. Because as a driver, he would have been in the first one to come up the driver, and I would come up to back him up on the driver's side.
Is it fair to say that you would be standing on the driver's side by where the passenger window is?
Yes, the rear driver's side door, correct.
And then the other officers, the ones that were in the Ford Explorer, what did they do?
Come up along the passenger side.
How many officers total approached this vehicle?
It would have been all of us, so it would have been 5.
5 officers. Do 5 officers generally approach a vehicle for window tint?
For the 15, yes.
For the 15. And why?
It's nearing 6 p.m. in Georgia, so I would assume there's a cutoff time there. But let's keep listening, because this is so far only the state arguing with the help of this witness, and they have another witness. But here's the thing. I will go on until 6 p.m. Eastern Standard Time. And if they're still at it, we will watch it tomorrow. I will begin a bit earlier tomorrow so we can listen to this and then continue with the hearing that is tomorrow. Yeah, it's a hearing both the 20th and 21st of November. And probably more.
Sure, we're targeting vehicles. Typically, we encounter weapons in multiple occupant vehicles, and as standard procedure, we're able to talk. Other officers are able to look at body language in this particular vehicle. Obviously, we're unable to do so, but that's why if you read the report, it mentions that we ask for all the windows to be lowered, so that way we can start reading body language and talking with the occupants of the vehicle.
You believe that's in that report?
Yes.
All right, may I?
Sure. In the second paragraph, it says we approach the vehicle and ask them to lower all the windows.
Okay. All right, and you stated that Mr. Nichols slightly opened the door?
Correct.
Okay, and what about the other passengers?
I can't recall what they did.
Now, once that Officer Owen, he's the one who asked Mr. Nichols for his identification?
Correct.
And you could hear that exchange?
Correct, I was standing right next to him.
Okay. All right, and Mr. Nichols stated that he did not have identification?
Correct.
Now, were you there, did Mr. Nichols, did he give his name?
Yes.
Okay. And he gave his correct name?
He did.
Now, the owner of the vehicle, she was also in the vehicle, correct?
Correct.
Ms. Gear? So once that Officer Owen asked Mr. Nichols for his identification and he stated that he did not have it, then what did you do next?
Sure, I would have escorted him to the vehicle, and I was the one who performed the inquiry on the computer.
Okay, when you say you would have, and I'm not trying to be funny,
Sure, sir.
I'm not sure if you're saying that's what you did that day or that's what you suspect you would have done. I don't understand.
My role in the FIT team was to run everyone's information on the computer. So I was the person who ran both Mr. Nichols' information as well as all the occupants in the vehicle's personal information.
Okay.
Okay, Fedorowski has something new on his channel. You can reach it by pressing his name on the chat, and then some bubble comes up that says go to channel. Do it after I'm done here in 15 minutes or so.
Mr. Nichols explained that he did not have identification. Was he immediately removed from the car?
He was.
So at that time, he was detained?
He was detained.
Okay. And did you walk him over to your patrol car?
He was placed in the rear seat of our vehicle.
He was placed in the rear seat. Okay. So at this point, Mr. Nichols is in the rear seat with you?
Correct.
Okay. And Officer Owens is?
Still at the vehicle.
Okay. Are the other officers, are all of them still at the vehicle?
They are.
At this point, are all the other passengers in the vehicle still in the vehicle?
Still in the vehicle.
What time, if you know, did this happen? What time was Nichols placed into your patrol car to run his identification?
Sure. Right after he said he didn't have the driver's license.
Okay, so are we still within a minute?
Maybe within 5 minutes.
Within 5 minutes?
Correct.
Okay, please explain what happened within the other 4 minutes.
Sure. We came with the vehicle, had the conversation. He didn't have a driver's license. He was asked to step out. He was detained, placed in the rear of the vehicle.
Okay. All right, so I just want to make sure because 5 minutes sounds like a little long.
Sure. That's why I said within 5. I'm not an expert on time. That's why I'm just simply estimating it would be no longer than 5 minutes.
Okay, so is the answer you don't know?
That is correct.
Okay. But you do know it was immediate?
Correct.
All right, you know you immediately asked for identification when he did not provide it. He was asked to step out of the vehicle. You know that happened immediately?
Yes.
All right, and you do not have any recollection that anything happened in between that time?
That is correct.
All right, and then you know that you walked him to your patrol car and that was immediate?
Correct.
All right, you didn't have any other conversation with Mr. Nichols between taking him out of the vehicle and walking him to your vehicle, correct?
I asked for his name and his date of birth.
And that's it?
Yes.
All right.
Well, and if his driver's license was out of the state of Georgia.
Out of the state of Georgia. Okay, so you asked him 3 questions and then you put him inside of your vehicle.
Correct.
All right, and then you immediately ran his name?
Correct.
All right, and how long did it take for the results of Mr. Nichols' name to come back to you?
It's instantaneous.
Okay, and when you received those results, at that time, were you aware that Mr. Nichols had warrants?
At that time, no.
No. All right, what did you do next?
Sure. Upon receiving information, we discovered that he was unlicensed operator motor vehicle, and then that's when I discovered that he had possible warrants.
Okay, so your first information received was a reference to the license, and then you found out about the warrants. I'm trying to figure out how long did that?
Sure, that part is instantaneous. Upon running his information in the computer, the first thing that comes back is his driver's license information, and then if someone was to have a possible warrant, that information will come up next.
Okay, so that's immediate.
That is correct.
All right, so you found that out while Nichols was still in the car with you.
Correct.
All right. And so once that you found out that Mr. Nichols did not have a license and had a warrant, what did you do next?
Sure, at that point in time is when Chisholm notified us that we had received consent to search the vehicle.
Okay. All right, let's go back for a second to the vehicle. The owner, Ms. Pierre, she was inside the vehicle. You just stated that, correct?
She was.
Did you ask her if her windows were factory tinted?
I did not know.
Okay. Did you ask her if she had any kind of medical exemption?
I did not.
Did you ask Mr. Nichols, he was the driver of the vehicle, did you ask him if he had any kind of medical exemption?
I did not.
Did you ask any of the passengers?
I did not.
At what point did you do the tent reading?
It would have been at the end of the stop.
At the end of the stop. And did you do that personally or did another officer? Okay. Did you, and so when you do the tent reading, the results come back immediately, right?
Yes.
All right. Did you take a picture of those results?
I did not. It would have been captured on the body camera.
Okay. A body camera that no longer exists?
Correct.
Okay. When Officer Chisholm, is that his name? Okay. Hernan. When she asked Ms. Pierre to step out of the vehicle, were you standing there?
I was not.
Okay. So you do not know what that officer said to, okay.
I do not.
Where was Pierre and Officer Chisholm? Where were they standing?
I can't recall.
When you walked up to the vehicle, or at any time, actually, did you see anything illegal in the car?
From outside the vehicle?
Yes.
No.
Okay. What about standing up close to the vehicle with the door open? Did you see anything?
No.
Could you see inside of the vehicle through the window tint when you were standing up close on it?
No.
You didn't smell anything that?
No.
So you asked, or one of the other officers asked to search the vehicle?
I would believe so, yes.
You believe so?
Correct.
You didn't ask to search the vehicle?
I did not.
Okay. You didn't have any indication that anything was in the vehicle?
Correct.
Who exactly searched the vehicle?
I was involved in the search. To my knowledge, this would have been the team. I couldn't tell you particularly. I would assume everyone that was on scene would have been involved in the search, but I know that I retrieved the firearm from the scene.
Okay, so you know you retrieved the firearm and you assume everyone else searched, but you just do not know?
Who did what? No, I can't recall.
Okay. And do you know how long the search of the vehicle took?
I don't.
The entire car was searched?
It was.
The female passenger, Ms. Pierre, she never gave you consent, correct?
No.
And you stated that Officer Chisholm told you that the female passenger said that you could search the vehicle.
That's correct.
Did Officer Chisholm tell you why he isolated Ms. Pierre from the vehicle and from her friends and family?
She did not.
At any point in time, did you give Mr. Nichols any Miranda warnings?
I did.
And when did that happen?
It would have been at the end of the stop. Once we recovered everything, I already ran it to all the occupants of the vehicle.
What time was Mr. Nichols arrested? Do you know that?
As soon as we found out that he was not licensed to operate a motor vehicle, he would have been under arrest.
Is it fair to say you have no idea what time any of this happened? Okay.
Yeah.
Is that yes?
That is a fair statement.
You're aware that when you call dispatch that they create CAD reports?
I am.
Is your understanding? Okay. Now, you're unaware of all the times. Is it fair to say that's what body cameras are helpful for?
They are.
They are. Because if you have a body cam, you can go back and you can review the body cam, right?
That's correct.
And then we would have an answer to a lot of these questions. Do you agree?
Yes.
All right. Now, you stated that the body cameras last for 5 years.
Correct.
Did you make any effort to locate the body cam in this case?
Yes.
Okay. Tell us about those efforts, please.
Sure. When I received a subpoena for this case, I asked for the agency case number, and then I looked into our evidence.com website for that case number and saw that it no longer existed.
Okay. All right. And that is a 5-year time frame.
That's correct.
Okay. So this incident happened July 3rd.
Correct.
And that's 2017?
Correct.
So when this case was originally indicted in May of 2017, this body camera existed?
I would assume so, yes.
And no one asked you in May of 2017 for this body camera footage?
No.
No. The field team and the primary responsibilities of the field team back in 2017, you did not observe any of those type of crimes being committed by the occupants in this vehicle, correct?
We refer to those crimes.
Robberies?
No.
Okay. I have no further questions, Your Honor.
Can you redirect, madam?
Okay, redirect. So they should be done before.
What happened to the vehicle?
It was released to someone at Ms. Pierre's request.
Okay. And what about the minor child?
To the same person.
Okay. And do you recall, did you have to wait for that person to come to the scene to retrieve the child in
Yes.
the vehicle?
We did.
Okay. Do you remember how long you had to wait?
I don't, but we were out there for quite some time.
No further questions.
Anything further, madam?
No.
Okay. Ms. Sergeant Maldonado will be permanently or temporarily excused for purpose of the motion.
Permanently, sir. Permanently.
All right. Sergeant Maldonado, thank you for your patience with us. I'm going to permanently excuse you for purpose of the motion. Don't discuss testimony to anybody except the attorneys in this case, okay?
Yes, sir.
Thank you, sir.
Okay. Come on. What now? What now?
All right, now.
Next we have Agent Chanel Chisholm.
Officer Chisel. That will be for tomorrow. This is a good cutoff point. I will start half an hour earlier tomorrow, so we can get the end of tonight, today's hearing, and start with tomorrow's hearing. As you've seen, this judge takes long pauses. Long pauses. Whew. All right. So the motion to for the language, the motion hearing was denied. The motion was denied, and now they are into a new motion of suppress. And we will see how that will finish off tomorrow. It's not a wild guess that he will approve having this in, but it will be interesting to listen to, at least. All right. Who is streaming now? Excited is on. Okay. Whew. Yeah. And let's get up to there. Yeah. Thank you all for showing up. Thank you for the super chat and the super sticker. Bring more tomorrow. And yeah, remember, this trial starts next Monday, unless something really interesting happens during these motions. But so it's a good warm-up for us all, because this will be a long trial. All right. Have a nice time. Have a nice night, evening. Say hi to Hella for me. And I will see you all here tomorrow. Bring friends. All right. Bye-bye.